Why would you destroy evidence if you thought that it was going to be helpful to you?
An experienced attorney uses science to fight for justice. Welcome to Make Your Case, the podcast where lawyers walk us through the cases that taught them something about the law, about storytelling, and sometimes about themselves. I'm Joe Douglas, longtime investigative journalist and founder of Clear Eyed Media, where we produce legal videos that help attorneys win cases and drive better settlements. Today's guest is Massachusetts appellate attorney Lisa Parlagreco. She takes us inside a case that started with a crash and a teenage driver convicted of a crime and ended against all odds with a huge settlement. This is a story about forensic bias, scientific thinking, and the fight to uncover what really happened. Let's get into it. Lisa, if you can, please tell folks about yourself and a little bit about who you are.
Sure. I am a native of Massachusetts, born and raised here. I'm a member of the bar. I've been practicing law for 35 years. Um, I've had my practice is pretty varied. I tend to focus now more on appellate law. I've seen the practice evolve over time, and you know, for just sort of on the big picture, and also on the on the micro scale for my own practice. And I'm sort of getting to that stage where I don't really it would have to be an extraordinary case, I think, for me to agree to get involved in a trial. Um, I really and if I were to do that, I tend to prefer to focus on the forensic issues in cases, um, sort of the intersection of law and science, which I find to be so fascinating. And that's really kind of what where I've been where I've been sort of drawn to. And it's just such a very interesting and ever-changing area of law. And
Hey, why are you drawn to that?
well, in part, it's just because I think I've always been very, there's, it's sort of like the left side, right side of the brain. I've always had just an affinity for the biological sciences. And, it's something that, for me, um, writing has been something that, has been a passion of mine for a lot of years, but also so was so was biology. My first wish was to be a marine biologist or an oceanographer, and I ended up taking a different path than that, with a little bit of frustration at times, seeing that the courts are always going to be behind the science, and seeing the law catch up to the science. One of my pet peeves, one of my absolute pet peeves, is the excited utterance exception to the hearsay rule. Um, what's an excited utterance? Well, an excited utterance is typically understood as an automatic reaction when you see something that's startling, that just overwhelms your senses, and you go, "Oh my God!" That's an excited utterance. It just bursts out of you.
Uh,
And the exception and the idea behind it is, well, it's reliable because the person didn't have time to stop and think about what they were going to say. It just came out of them. And kind of, like, we've all had the experience of seeing something or experiencing something that is just like, it's sort of like a shock, and you're not in control of what comes out of your mouth. In practice, though, you know, things that people say on the phone talking to a 911 operator will sometimes come in as an excited utterance. Well, I think it was Mark Twain said, "A lie can get around the world faster than the truth can get its pants on." And it doesn't take very long for the brain to come up with a fabrication. Neuroscientists know that. They've worked on this, they've studied it. There's a lot of scientific research on it. But we're still stuck in this idea that, oh, no, 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 it takes time to think and to fabricate a lie. Well, it probably takes milliseconds. Um, Certainly doesn't take a long conversation or minutes. Somebody runs up to the car and jumps in and makes a statement that implicates another person.
Mm-hmm.
That's probably going to come in as an excited utterance, but should it? How much time went by? It's not, the gun goes off and someone screams, "Oh my God, so and so just shot a guy." No, somebody's run across the parking lot, found their friends, jumped in a car, and then made this excited utterance. And so that, there's sort of I'm kind of like tilting at windmills in a way. Um, but it's uh, one of my sort of pet peeves, something that I've argued against, sort of railed against, uh, tried to do my best to write a Brandeis brief on the issue, and
Mm-hmm.
any opportunity I get, of course, I got to keep hearing my argument on that one. Um, so that's why I'm just very quite fascinated by it, and it's really interesting when we see how the law, when it does change, it's really satisfying when it does kind of catch up to science, when we start to recognize, like, the work of some of the work of Dr. E.T.L. Dror, who's a cognitive neuroscientist who has been very, very, very active in researching bias in the work of forensic examiners. And a few years ago, this is sort of going back before the pandemic, I had the privilege of attending a couple of different seminars that he gave about how cognitive bias can infiltrate the scientist's perception and the examiner. What does the examiner need to know about a case? Well, the examiner, if you're examining fingerprints, for example, and hoping to make a match with fingerprints, that's, a fingerprint, lift the fingerprint, compare it to other known prints in a database. Do you really need to know anything at all about the victim? Why does that examiner need to know who the victim was, um, and and anything about what they may have gone through as the victim of a crime? And the answer is they don't need to know anything about it. It's not relevant, unless it is relevant, knowing that, okay, this print, you're going to take the print off the victim's body. No, no, you're making an examination of something, potential piece of evidence. You don't. Some I've read, one justification that has been put forth is, well, we want these forensic examiners to feel like they're part of the team. Well, there's a problem when you take the scientist, who is supposed to bring simply their scientific judgment, their training, their experience, their technical judgment to a case, and make a determination: is it a match or is it not a match? And making them feel like they're part of the team puts them in the role of whether consciously or not, um, you're putting them on into the prosecution, and they're not properly part of the prosecution. They should be independent, unbiased, and not subjected to things that can subconsciously influence them. And that is really what Dr. Dror's work is focused on, and he's been extremely influential,
Hmm.
and we're
Okay.
making progress.
But don't they
Uh,
know that from just getting where the request comes from or who's paying their bills?
you would think, but a lot of the information that is given over, though, is going to come from the prosecution and the police. So, it's how to set up those channels so that you know, they are not they're not exposed to extraneous information.
Like
There was
what?
a um eh, primarily like about the victim. And for example, there was a case that I worked on, and the victims, there were two Jane Does, and it took years to identify. It was a mother and daughter who had been the victims of homicide. And one was found in Massachusetts, and the other was found in Connecticut. And it was, there was some extraordinary work was done by forensic anthropologists, sort of trying to, because they had they had no information about who these people were. And it took, I think, 18 years to identify these people. Um, so, does it matter? Does it matter for the purposes of doing an identification of an individual to know that the person was you know was beaten, was left in a on the side of a hill and exposed to the elements and just all sort of the gruesome details
Hmm.
of of how the body was, the state of the body when it was found. Appropriate for the coroner to know? Yes, absolutely. The medical examiner is going to deal with those issues. But does an analyst who's lifting prints off of a plastic bag that was found in the vicinity need to know that the victim was a 14-year-old girl? Is that relevant to determining, does this fingerprint match any of the known prints in our database?
Are there rules in place that is that something that's defined by law, or is that just something that you're like you would like on a wish list for you, or something you try to make happen in your own cases, or
So that's a great question. And it's not so much that it's defined by law, it's more a matter of the National Association of Criminal Defense Lawyers working in conjunction with the FBI to come up with guidelines for forensic scientists, and also FBI and the Department of Justice. And what I've seen is there has been some there's been some agreements have been reached between NACDA and FBI/DOJ with regard to best practices for forensic laboratories and how evidence should be handled. This is sort of this is getting a little bit far afield for me because that's not something that I'm involved in
mm-hmm.
working with anybody on those things. But I am certainly aware that there has been some movement and progress there, which is quite nice.
Have you found that those are generally followed, or is it just kind of not always followed?
I think it varies. It would vary from state to state. Crime labs are accredited, um, or at least I believe that certainly the Massachusetts Crime Lab is goes through accreditation
Mm-hmm.
process. And how often they're accredited, I'm not really sure. But they do, they certainly do. And I think that most labs, most state forensic labs do.
We kind of start out open ended here on this podcast a lot of times with attorneys, and I like to kind of see what you start out with. And you started out with this point about being a scientist, and then this very, to me, very scientific point, almost like a double blind study or something, where you're like, you know, what may like, and we'll kind of go into like a big case that you want to talk about that for you is very notable and impactful in your career. But it's interesting that you brought that up. Do you apply sort of like scientific method to your practice of law, or do you kind of think that there should be a more scientific approach legally, or what made you want to bring that up right away?
So I was thinking, what made me actually think about that was that I was thinking about yeah, the short answer is yes. I do try to apply sort of a scientific a scientific approach to my practice, and bring to the cases that I look at, whether I'm simply a consultant on a case or whether I'm hired to be part of a case. Um, and there's a book that really helped to kind of crystallize my own thinking on it. Um, and the book it's called Black Box Thinking by Matthew Syed, and I found it to be quite fascinating. And he has a very nice, and it's a very approachable book. I think the name Black Box Thinking comes from the idea that in the airplane, of course, there's a there's a black box that they try to recover from an airplane crash and get whatever data they can from that. Similarly, a lot of commercial vehicles have sort of like a, you can call it something like a black box, where there's data that's been stored, and you know to varying degrees, we can learn a lot about what was going on in the seconds before a crash occurs. Um, and just the idea of taking a very open-minded approach and putting aside the preconceptions about what we think we know happened based upon pictures, witness accounts, and looking at, approaching something with kind of a very open mind, because we make judgments very quickly.
Yeah.
You give somebody a photograph of a crash, and they can go, oh, well, I've seen this happen. Well, you can see what happened. You can see who's at fault just from the picture. Really? You know what happened in the 10 seconds that preceded this crash just from looking at a photograph? Well, I suppose maybe there are times when you can. If, car number one crashed into the rear of car number two, it's highly likely that car number one is at fault. But when two cars meet, this or like this or like this, you know, who really is to blame? And if you just take a look at a photograph and draw a hasty conclusion from it, you can be very wrong. And so this book has been quite influential, and it also, something I like to say, is that it, I sort of rail against the saying, think outside of the box. You need to think outside of the box.
Mm-hmm.
And I have an answer to that, which is, you never have to think outside of the box once you realize that there really is no box. There's no box unless you put yourself and your thinking into a box, and you put up these invisible,
Yeah.
be the mind walls. And I
Do you
think,
find when you get a case like so this is something where I can kind of relate to this myself as a journalist because I get you get story. I worked in journalism for like almost 20 years. So you get a story, you get a your editor tells you, okay, there's this case, this lady did this thing, we heard whatever that she, whatever, she kidnapped her son and she blah 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 side of the road. That's what we're hearing. Go find out, blah blah blah. And then you get down the road and you find out that's all BS. It's a completely different story. She's the victim. The whole thing is a complete, you find out everything as you piece it together, like you're saying. Is that sort of a similar thing that happens when I would imagine as a lawyer, you get a case and you hear the pitch from so and so, and is that kind of where you're going with this, or what? I mean,
um,
or is it just the whole
yes,
enchilada, the entire thing?
sorry, yes and no. Yes and no. Um, so I will answer by shifting into a situation that I found myself in, a case that I worked on.
Mm-hmm.
And instead of giving me this is what happened in this case, the lawyer that I was co-counsel with this firm, and he decided that he wanted to get me involved in a case that he had. And he did something really unusual. He came to me with a photograph and he said, I, I want you to think about getting involved in this case. I would love to have you get involved in this case, but I'm not going to tell you very much at all about the case. I want to give you these photos first, okay? I want you to study the photos. And then after you study the photos, come tell me if you want to be involved in the case. Now, I should tell you that every other lawyer who looked at the case turned it down.
Mm-hmm.
And there was a terrible, terrible crash that was quite evident from the photograph. And I was told that the client was a young woman who had been horribly injured in a crash, and she was in a minimally conscious state. She'd essentially never regained consciousness following the crash, and it had been almost 3 years post crash. And it's so I know that there's a young woman who was in a car in a and yeah, was basically required 24-hour care. And this lawyer, he handed me a series of photographs. And from the pictures, you see a cute little sporty little red car. Little 12, it was like a 12-year-old little bright red BMW, and red's my favorite color. And it is basically looks like it's stuffed into the front of a bus. And
What kind of a bus?
a school bus.
Mm-hmm.
A school bus, a big yellow school bus, the biggest one. It
Wow.
had been a brand new
That's a
school.
very intriguing image.
And the it's like the image shows, when you look at the image, it's from the side and it shows the left, it's the photograph of the driver's side, and the front driver's side wheel is pushed back about I don't know, about 2 to 3 feet. They just forced backwards. They had to use the jaws of life to get into the vehicle, to get the passengers out, to get all the occupants out of the car. And so you see this just the hood of the car is crumpled, and that wheel is pushed backwards from the force of the impact essentially into the driver's door. That's how much it's just crushed the front of the car. And then I looked at the next photograph. And the next photograph was the passenger side of the car. And what was really intriguing was that the passenger side of the car, from the photograph angle, there was nothing wrong with it. You could take the fender off and put it on another car. You could take the door off, put it on another car. There was no visible impact to the right side of the vehicle. It was all on the left side of the vehicle, and this was described as a head-on crash. Well, a head-on crash is this. It's when two vehicles, they meet. This actually was an offset crash, which when you start to, you start looking at the photographs, it's like, well, no, it's not really a head-on crash. It's sort of like, so like this. It's like this.
It's at
Why
an
is a
angle.
car like this? Because was it that it was trying to go someplace else? And there was clearly a rush to judgment in the case where everyone looked at the scene and said, yeah, I mean, everybody knows what happened here. The driver of the car that was was on the wrong side of the road and crashed the bus, and the bus wasn't at fault. And after studying the photographs, I said, yes, I want in because this wasn't a head-on collision. I don't believe that these photographs show a head-on collision. I don't yet know what it was, but there are too many things that I see in these photographs that I want to understand.
Right.
And, you know, it was presented to me in a black box thinking way. No extraneous information, no prejudgment. Now, let's figure out what happened. And uh, it was, it was, just a fascinating experience to be a
Sounds like
part
this
of a.
person knew you pretty well because they knew that that would make you tantalize you, right?
He did, yeah, he did. And it's like, when a bunch of other really smart tort lawyers turn a case down, they've got good reason to, because they're looking at it going, I
Yeah.
don't know, it's, you you're gonna, you might be chasing windmills here. But that's okay. It's fun to chase windmills. Sometimes you slay a dragon when you do it. Um,
So yeah, so tell us about this. Is this the case? It's the impactful case, the one that came to mind for you that we're
yeah,
diving into. So tell
it
us about it, and then yeah, talk about this process. And one of the things that we kind of focus on too is it's really interesting the way your scientific approach to law is fascinating, but also just and then how you ultimately make that into a story that you're going to tell to a jury or to
right.
mediators or whoever, a judge. And how do you sort of like synthesize this, not even just the data, but the process and everything else into like, how do you decide like to not, spray a fire hose of data at people and just take them through piece by piece and tell the story? And like,
Yeah.
how did you do that with this case and what were the challenges you faced?
Oh, so it was fascinating. It was fascinating because it was by the time we got to trial, we knew we knew the story of the case because it developed for us. We followed, we really did follow the evidence instead of trying to let the evidence, um, I mean, or let the evidence lead us. And I was really given a free rein to to pursue aspects of the case because my colleagues were it, and this was a case where there were three law firms involved in the case, and I worked very very closely with a lawyer from one of the other firms. Can I say his name?
I
Oh,
think
yeah.
that's fine. Go for it.
A great, fabulous person to work with, Jeff Beeler of Heinlein, Beeler, Mingus, and Heinemann. And he was, I think in a lot of ways, Jeff really, really moved a lot of what we were trying to accomplish over the rail with with my colleagues because we were sort of two like-minded people in terms of approaching the case. And the first thing I started focusing on was GPS because we knew that the vehicle had GPS um, tracking data, and
Mm-hmm.
so we received some information through discovery that there had been some disclosure between the GPS tracking company and the bus company because the bus company had they had this device on the vehicle, and it was being tracked supposedly in real time. And the company back then used to they had this advertising campaign, and they would um, they would actually send letters home to parents boasting about how they were so good, their software was their their tracking software is so good that they could pinpoint the exact location of their school buses at any moment.
Mm-hmm.
To me, it's like, cool. Let's see this stuff. Let's see this data. And I had some very, very limited data, and I knew enough about GPS to know that there's a lot more. There's certainly got to be more than they've given us just for like the short period of time before and after. So come on with the rest of it. And ultimately, I think I had to go to um, out to Washington State and get a. We ended up hiring local counsel out there because we decided, okay, you know what? You're a bus company. You're not in the business of making tracking software. So we're going to go talk to this company that actually built the tracking software that was on your school bus. And we did that, and they produced some information communications that let us know that the bus company was concerned enough about what what had happened, that they were that there was contact that day between someone acting a lawyer acting on behalf of the bus company
Mm-hmm.
and the the company that tracked the bus. And so the tracking company, they took the GPS and they started plotting it and mapped it out. And, uh, they sent those maps to the basically the bus company. It's like, here you go. And we got hold of that
Mm-hmm.
and said, gee, that's kind of weird. That kind of GPS data sort of makes it look like the bus is in the wrong lane. Um,
Mm-hmm.
this is this is not what they're saying. It's let's dig some more. Let's
Yeah.
let's keep following this. And you just keep on following. And the other piece of information was there was a video recorder on the bus that was pointed backwards at the students, so that if the kids are misbehaving, there's something going on, and so that's really the purpose of it. But it also provides a secondary purpose, which is, as the bus is traveling and it's got this really, really, really heavy duty industrial grade camera that weighs about 10 pounds. Thing is solid steel. I mean, I've never held a camera that weighed so much. It's facing, and it's got a pretty good wide angle camera that shows you what's going on out the back of the bus, to the sides of the school bus. Now, it's not perfect all the time, but you can see a lot of movement. You can hear what's going on. And it was a challenge to get a hold of that video. And when we
Why?
did finally, I'm
What
sorry?
was the challenge?
Well, the challenge was that the original videotape was taken by the it was taken by the DA's office eventually. And there were some questions about how long it took to get to the DA's office. It wasn't there wasn't really a good clean chain of custody showing that it was removed from the bus and given to the police on the scene, because the officer was who was who took custody of it, well, he just wasn't really clear, and had um, had suffered a work injury, and so he had some memory issues. So
Mm-hmm.
poor guy, it wasn't his fault, but it was just a little bit unclear, because he had a memory of turning it over of getting it from the bus company's lawyer, and so it was unclear. But what was not unclear was when you played this VCR tape back, um, it had it ran for 4 hours without any problem. It would go on automatically. Turn on the bus, the VCR turns on, starts recording. And the it was several minutes right before the crash happens, and it just there's no there's no there's no recording on the screen. There's no sound on the screen. It's just this very strange static. Not like, and it's not static like, I don't know if you ever have seen, that, well, you can get an effect that looks like snow, when TVs would go off.
Yeah.
Okay, so that analog snow, where it's just all that black and white flickering. Um, it wasn't that kind of static. It was like these flashing lines would jump and little boxes would appear, and so you'd have like a lot of like sort of very, very speckled snow, but all these strange artifacts are just
Hmm.
springing up. It's an 8-hour long tape. It's the only, and there's just this long section there that it's the only period of time when it shows this very, very, very unusual artifact. And it comes back in the sound of the crash. And it's like, well, that's just a little bit too convenient that
Right.
the video recording goes in.
Hmm.
So I could understand, little bits and pieces, but for it to come back in, and someone suggested, well, maybe when the vehicles crashed, maybe that, knocked it back into functioning properly. And in my experience with mechanical devices, they don't work better after you throw them out a window,
Right.
or, essentially, or the equivalent of that, which is what this crash
Yeah, it's like
was.
the Fonz and Happy Days, like hitting the jukebox. I'm aging myself, but it just doesn't. Yeah, it doesn't happen.
And
It's like,
no, it doesn't happen. And so we recreated the video system. Jeff Beeler and I, worked together, and we found the exact make, model, camera.
wow.
We found the exact make and model of VCR, hired Rampion Video Productions. Little shout out to Rampion, Mike Garneau, and Steve Tringali for their
Mm-hmm.
amazing work.
Cool.
And what we did, so we replicated this video system because we were wondering, is it possible to replicate this static? And we ultimately were able to get the DA's office to allow us to make a frame-by-frame duplication of the original videotape, which meant that a representative from the DA's office brought the video to Rampion, and she was there for the entire day because it took I think 12 hours to make that frame-by-frame transfer. And then she left with the original videotape,
Mm-hmm.
and when I stayed, and Mike Garneau started conducting some tests to see if he could duplicate the static. Um, and he went through a very, very, very methodical process of, like, disconnecting certain things. I don't remember exactly what it was that he
Trying
did,
to replicate that issue, right?
trying to replicate the issue.
Mm-hmm.
And we didn't have too much success initially, and it'd been a very, very long day, and so I remember I left, and I called my colleague Jeff on the phone and said, well, so far we haven't been able to replicate it. I just got off the phone with our expert, and he said, well, did you have, and I can't remember what the last one was. It was something that Jeff had specifically wanted them to do, and I just, oh Jesus, I don't remember if we did that or not. But I'll call him. I'll call up Mike, and I'll make sure that he does. So I did. I called up Mike, and I said, wait, before you take it apart, there's one more thing that you got to do, please. One more test to run, and it had to do with, essentially, very simple, disconnecting the camera feed at a certain point.
Yeah.
disconnecting the camera feed.
Yanking the cable
I
out.
think that was it. Yeah, and it was, and it was like, interrupting. They had to get a generator because I think it ran on whatever was it AC current that vehicles use? Whatever the current was,
I don't
it's not
know.
whatever, yeah, whatever the electricity is that comes into the wall,
Mm-hmm.
it's not that.
Okay.
So, um,
Wow. So yeah, that's a lot of work. Yeah.
it's a lot of work. It is a
Mm-hmm.
lot of work. And I'll never forget getting a phone call back. And because and I'm going to paraphrase Mike Garneau. It's like, I mean, on these cases, whenever there's a video, he's had a lot of video cases where he's analyzed a lot of video or recordings,
Yeah.
and it's tampered with, and it's never turns out to be tampered with. Finding a video tape that had been tampered with would be like finding, almost like finding a unicorn.
Yeah.
And I remember he called me up and he said, Lisa, you got a unicorn.
Oh, wow.
When he disconnected the camera input, it duplicated the static exactly.
Wow.
And what I understood, the cause of that kind of crazy jumping, flashing static is because the camera is generating, it's still generating an image, and it's looking for the feed to connect with. I don't really understand this, so
It's
it's
unique to that issue, sort of.
extremely, extremely,
Yeah.
and part of the scientific process, can you duplicate?
Of
Can you
course.
duplicate?
And
Um,
also have an expert, a sanctioned expert, sort of bless your findings or find them themselves, right?
yes, yes,
Yeah.
precisely. And so what it started out as a case where the young woman who's driving the vehicle had no memory. She
Yeah.
she had pleaded guilty to, I think, reckless driving. It was and yeah, had lost her license for a period of time. Um,
So
it
no
was a
wonder people were turning it down.
yes, yes,
But you
yes,
still saw through that.
yes, I did. Yes, I
Wow.
did. And said, I'm willing to do this because, and there's everything pointed towards this not being what it appeared to be initially. And during the trial, we actually finally heard from the expert for the defense, and their expert reconstructionist, and he had been on the collision scene a couple of weeks after the crash,
Yeah.
and he saw what he claimed to be a gouge in the roadway, things that were not seen the day, he based his opinion that, in part on what he found that day. Um, well, this was a fellow who had been the head of the collision reconstruction unit. That's the state police unit that goes out and works on, on major crashes when there's been a vehicle crash and serious injuries. They go out and they examine, they investigate. And
Mm-hmm.
this guy who had retired from the state police and was working as a collision reconstructionist privately. And he came up to Massachusetts, and just a couple weeks after the collision, and he noted things in his report that the actual reconstructionist who had been on the scene looked for but didn't find. You look for gouges in the roadway. You look for, to see if there are any tire marks, but especially a gouge in the roadway is indicative of basically, that a vehicle's driven down and it marks the road.
Mm-hmm.
You claim to find it. You found it. And you saw the reconstruction report that the officer for the state police did, that you trained, and you knew he didn't see that, he didn't find it. and it wasn't important for you to maybe bring that information to his attention,
Yeah.
which it's like, or maybe he didn't see it because it wasn't there the day he examined the roadway.
Hmm.
Um, I know what I think, and I think I know what the jury thought, because they certainly didn't believe him.
So you had to take on not just the defense counsel, but you're really taking on the state. Like you're taking on the state's case. This woman was convicted
Yes,
of
yes.
criminal charges in a car crash.
17 years old.
To be clear, that 17-year-old girl, the driver of the car that collided with the school bus, was convicted of reckless driving in the case and thought to be the sole culprit of the crash. Lisa's client was one of 3 passengers in the car who sustained severe injuries.
So you had a sense like there's something, you smelled it, like, okay, I've been around the block. What was it? What was it that kind of drove you that? Was it a challenge or was it kind of like,
I would say that it was all of that. I knew that I it as I got further and further and further into the case, that momentum just was building as we were finding more and more things that didn't didn't smell right. They just were they just they were just wrong. They were just wrong. And the explanations for them, you know, there are only so many coincidences that you can accept as, well, it just happened. It just happened. It just happened that the video stopped before the crash and came back in after the crash.
yeah,
And just, and
yes,
this poor young woman whose best friends are, one's in a, I mean, in a horrible, horrible,
yeah, it's
horrible
awful.
injury.
It's absolutely
Second
awful.
one, horrible injuries.
Yeah.
Third one, terrible injuries. 3 young people with brain trauma. And this young woman has no memory. She's unconscious. She basically regains consciousness at the scene with with chest injuries, concussion. She actually stopped breathing at the scene, and they I think her heart didn't stop, but she did stop breathing. They had to get a chest tube in her, and and I basically, she she doesn't know what happened. One minute, she's driving her friends to school. Within, she's a half a mile away from school, and then she's next thing she knows, she's in horrific pain, staring at the front of a school bus, and one of her friends, she can't even see her because she's underneath the dashboard that is completely crumpled. Um, Horrible, absolutely horrible.
So what was the outcome of this case and what were some of the other challenges that you faced?
Oh my gosh, there were so many, so many challenges. Um, not the least of which being selecting a jury that of people who didn't know anything about the case because there'd been a fair amount of publicity about it, and so we had to uh, find jurors who weren't familiar with the case, jurors who could be open-minded about it, finding getting a fair cross section of the community, and something that we're jury selection is so important when it comes to trying a case, because you want to find people who'll be open-minded, and we'd had a couple of focus groups, and it was really insightful to see how when a focus group, it's you basically have 15 minutes to present your case, and then you present the other side of the case and give give these people who are acting as jurors some, information, maybe feed them some more. Basically, you're just watching this happen, and you have a facilitator there, and just seeing how people reacted, seeing how people responded, and what um, what were the things that just kind of stood out to them, and in a negative way. What for us, what were the things that um, were 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 problems for us in terms of in terms of
Yeah.
presenting a credible case. So that so one of the things, and so we knew. I want to say we knew what we wanted in terms of, in terms of people who would come to it, would come to this with an open mind, and not simply make a decision when you see that picture of that horrible picture. The camera turned off. Well, and so the defense to that was, oh, everybody's dealt with these old VCRs, and they eat the videotape, and they I think they had a they had it was kind of like, we'll take this very folksy approach to this evidence and say, well, there was a police officer who had worked at a video store when he was a teenager, and he would like clean VCRs, and um, they managed to get some testimony from him about how unreliable they are. Well, yeah, the VCR you bought for $199 at Best Buy is, not the greatest piece piece of equipment, but a commercial grade VCR that is screwed to the floor of a
Yeah.
vehicle that is, it's these things are meant to withstand abuse and tolerate abuse. And this wasn't explained by a wear and tear of the repeated wear of the on the videotape. Um, not when you can recreate precisely what happened. There was there was a lot of, sort of, it was an uphill climb for us. It was definitely an uphill climb. And
So when you're presenting that to the jury, though, do you think like this is like the Columbo approach? I mean, Columbo is an extremely popular television show for a reason. It's
yeah,
not silly to try to tell a story that way if it works, right?
that's
Was
right.
that kind of, I mean, that like, that's scientific, that's evidence driven. Is that kind of, I
Yes.
mean, I know you're not trying to be like Peter Falk, but like, I don't know. I mean, what was your approach to getting that across to the jury through that giant, like, impenetrable fortress of criminal conviction and the picture? How did you punch through to the jury about that?
Well, I mean, that's a great question. That is a great question. And it's, again, going back to my observation of some great trial lawyers. They they present the case, and you have to think about it piece by piece, brick by
Yeah.
brick. You're building the foundation for it, laying the foundation for it, and letting, from the opening statement, letting the jurors know what you anticipate the evidence is going to show, giving them that sort of preview, and um, of what the evidence will be. And there was a lot of coordination, because we had, three different plaintiffs, three families, three different law firms. So there was a lot. We all worked together as you know we had our own clients to represent, but we had really one story to tell. And so there was it was in just sort of a wonderful way. Um, each firm brought different strengths to the process. One of my colleagues had had actually been a commercial vehicle driver, he was a licensed commercial vehicle driver, and
That's great.
knew that about certain aspects of driver training and driver testing, and um, had really taken up the mantle of pursuing that line of the case, and that ended up being very significant during trial because um, they the bus company um, in the middle of trial produced materials, documents and materials having to do with this particular driver's testing that they had been ordered to produce during discovery. Order to compel was allowed, and those documents weren't produced until we were on trial, halfway through the trial, and it resulted in you know in some information about the bus driver, the 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 test of her skills that was most close in proximity to the collision was produced during trial, and during that testing, she had I think like there were several unsatisfactory scores, if I recall. Nothing that was a failure, but she didn't pass it with flying colors. So it was we were to the extent our view was that they were we had to go and ask a court to order these materials to be produced because we felt that there was information that wasn't being produced, and we were right. Ultimately, we were right, and even though there had been an order issued by a judge a couple of years before we tried the case.
Wow.
Um, the to be clear, the lawyer who represented the bus company at trial was not the same lawyer as the one who represented them during the litigation phase of it, and he was actually the person who produced those documents to us. And
Mm-hmm.
and for anywhere that would be a terrible situation to be in, to have to essentially say, I think you probably want these,
Right.
you know, and we ultimately that kind of behavior by a party has to be punished from the judge's perspective. You can't just look the other way and
No, it's
ignore
horrible.
that. And there was in a criminal case, if somebody runs, that the jury will often receive an instruction of consciousness of guilt. You don't nobody runs unless they know they're guilty. In a civil case, um, there's a instruction called consciousness of liability. You don't hide documents unless you have something to hide because you did something wrong. And
Mm-hmm.
because of that, the sanction that the judge granted was to give an instruction to the jury when they went to deliberate about the case that they could consider this. The judge explained to them that this had been ordered, that the company was required to produce these. They produced them during trial, and you don't have to, but you may consider that as evidence that they knew that they were liable for this crash, that they were at fault, in essence.
And then was there an issue with the GPS data as well? Or
There was, and we had to, it was that was sort of a challenge for us because um, we ended up having to hire a lawyer in Seattle to help us just get information from this GPS company. It's like, we weren't really requesting anything extraordinary, I thought. Um, we wanted to know, because this bus company was sending home all these fires saying, pinpoint, 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 pinpoint. I mean, I had so many documents that they'd written where they said it's pinpoint accurate. We tell you where your kids are. We've got it We've got access
Yeah.
to this information in real time. So back at the manager's office, there's a report there's been a crash, and the manager can see exactly where that bus is in real time. You can pull up that data and see what the GPS said about its travel history. And so we just, give us what you had, and the bus company, well, this is all we had. So, all right, well, that's not very
It
much.
was like
So
limited to what? A scope that was you wanted a wider scope of data,
wanted a
obviously.
wider scope. We wanted manuals and information
Hmm.
that they certainly, we knew that they had. Well, actually, we found out that they did have later. Accuracy statements and things like that, reflecting on how testing that the GPS company had done, in terms of whether, what they said about the accuracy of their own product.
And
So
they were they hiding that?
the the
Was the company kind of hiding that information, or?
they considered it, well, the GPS company considered it proprietary and
Oh, okay.
confidential. So this is
Couldn't it be
summer.
sealed in court though? I mean, by a
Well,
judge?
it can be, and so we went out to, we ended up going out to Seattle and
Hmm.
getting an order from a judge compelling them to produce some materials, um, and I before they produced the materials, um, they gave us a privilege log. So, we have this, but we're not producing it, but we'll describe it. And they said that what they had was a accuracy statement from it was like their chief engineer. And it was summertime, and I was home with the kids. And I get on the internet, and I was like, oh, who is this? Who's their chief engineer? I Google, and 2 seconds later, I get the name of their chief engineer. And it's like, wow, cool, great. And they said accuracy statement. So I do a little Google search. I put his name in, and I put accuracy statement in quotes. And I go search, and the first document that comes up, it's like a PDF from this corporation accuracy statement. So I click on it. So I click on it, and it's like, whoa,
Pay dirt.
Peter. And I'm like,
Hmm.
where am I? I'm at their website. And I'm like, all right, well, what if I just like shorten the URL a little bit? Click on it. Now I'm really in their website. I'm getting like all these documents that are like cool stuff. It's like manuals, instructions on how to use this, what the equipment can do, how you get this accent, how you get that stuff, all this stuff that they're like, well, some of it hadn't, I don't think they'd even disclosed that they had it. So
Were these materials that they were basically content, like not trying to not release?
yeah, yeah, yeah,
Okay.
yeah, yep. They
Or not released to you through the court.
correct. Yes, that they said that it was proprietary information that they wanted. We're going to have to file like a confidentiality agreement and
Hmm.
all this, and it was. I mean, basically, there were documents that I think they kind of suggested they didn't have, but I would say that I found things that fell into the category of they do have, but maybe I interpreted them a little bit more broadly than they did. Let me just put it that way.
Yeah.
Um, so I contact the lawyer that we have representing us in Seattle, and because because they say, we don't have these documents. We don't have any, we don't have any such documents. We don't have all these other, these things that they're asking for. And so I said, well, guess what they do? I got 1,000 pages I downloaded uh, from their website. So, so we go, all
Wow.
right, well, we're going to file a response to that. And so put together a declaration basically saying, Judge, we know they've got it. We know they've got all these materials that they're saying they don't have because I found them. And here's a list of them. You can take a look. it was like Mount Rainier exploded. And you could hear the explosion all the way from Seattle. The lawyer who represented the GPS company got on the phone, called up the other lawyer that was representing our clients, and outrageous, terrible, horrible, bad, very bad. And I was like, hey, sanction, sanction, sanctions. It's like, how do you sanction me? This was on the internet, so
Right.
that they did not get any sanctions. And when I went out to Seattle to finally take the company's deposition, the lawyer representing the company did something that's kind of unusual. He decided to ask his own client's representative some questions. I mean, you don't have to ask your own client questions at a deposition. You can ask them questions at trial. But
Yeah.
he said, he asked the witness, he said, Attorney Parlagreco put some documents in front of you, and um, are those things that you make available to the public? Oh, no, no, no. Are those proprietary documents? Yes, yes, they are. Are those on a part of the website that's accessible to the public? No, no, no. Well, he said, look into the camera and tell the jurors who are listening to this whether or not anybody could just access this document. Well, it's in a part of our website that we don't give customers access to. Well, I'm not going to let that go by without responding to it. So
Right.
I said to the witnesses, all right, now I'm going to follow up question. I said, so at some point, did you learn that there was an issue with your website? Yes. Well, what was the problem with your website? So some of the engineers had done some upgrades on it, and they hadn't secured the website. So anybody could go on your website and get access to documents? That's correct. And get access to this confidential statement?
Yeah.
Yeah, that's right. And how was it that you found out that your website was open to the public? He said, you told us. And I said, no further questions. And that was, yeah. And the court in Massachusetts took a different view than the court in Seattle did. The court in Seattle said, well, I don't think you've given up your proprietary rights. And at trial, the judge said, if you found it on the internet, it's public. So we were not required to go through a lot of machinations to protect the data. Oh,
Wow. And
yeah.
so that's just that's a crazy case with a lot. I mean, I'm sure there's a lot more, but the outcome of the case was what? And then what were the findings in the GPS? If we could summarize them, like what?
Well, actually, what was interesting was that, and this is, the GPS really was not pinpoint accurate. We knew it wasn't going to be pinpoint accurate, and there's we were able to. I mean, the only way you can get pinpoint accuracy is if your GPS is connected to a ground station. That's basically survey grade GPS. It's kind of GPS that, when you're landing airplanes,
Okay,
it's a level of GPS that is military grade,
mm,
or the next level would be
that's
survey grade.
interesting.
Um, so so but it was certainly that was the perception that the company was presenting about how accurate their GPS was. And we were able to show that the videotape evidence had been tampered with. And that ties in with their statements about their GPS. Why would you destroy evidence if you thought that it was going to be helpful to you? You wouldn't. You wouldn't. But if you believe that your GPS was pinpoint accurate, which is what they said, then there's your motive right there to destroy evidence.
So did they use that claim of its accuracy in the case to prosecute this woman, this young lady, this teenager?
They
Just
actually, I don't think that they didn't, the Commonwealth didn't have to, because the police did their initial investigation, and
hmm
the Commonwealth relied upon the police investigation, which was, it's her fault. And so no, the answer is no. They didn't really do much more investigation, and she had no memory of it.
yeah.
So
But in terms of like their claim or the marketing materials and a lot of the sort of external communications of the company were selling it as this pinpoint accuracy. But in terms of the case though, was that part of the defense that were they trying to say or no? How was that? How did that come up from their perspective? Because they're
they
hiding what the reality is. But
they
what were they,
I will say that I think that
or potentially hiding it? Yeah.
they they um they never understood our approach to the GPS, because um, they made certain assumptions about how we were going to use it, and they were wrong. And they thought that we were going to say that GPS is pinpoint accurate, which was not what we did.
So was it your strategy or focus to like your hypothesis was that they were probably not telling the truth about the accuracy of it and that would show that they were not a trustworthy or reliable source or what
That's
was
that's that's part of it, but
yeah.
the there was an individual who was on a had passed away, right before the case was filed, who was the person who had um, who was he was the person who coordinated the company's response to the crash, who had
Yeah.
access to the data, and had also was the person who um, had access to the bus. Um, we see him on the bus. The videotape shows him on the bus. He was the person who had access to the BCR when it was supposedly, yeah, it wasn't ever impounded at the scene, but he and several other employees were given free access at the crash scene.
Mm-hmm.
And he coordinated the response and was responsible for any handover of the VCR. And sort of like in explaining, we used it in terms of um, explaining what trying to get into their heads, if you will. Why would you do this? Why would you destroy evidence? You wouldn't destroy evidence unless you knew it was not favorable to you. How would you know it's not favorable? Because before any of these people could come to the crash site, they could look at the GPS, which if they believe what their company said about it, and they're just, their job is to, they're dispatchers, and they're not highly trained in terms of the equipment, but they should know how to operate the system, the tracking software, and it would show if they looked on the map, and we saw what the company gave to them afterwards. When it shows the bus in the wrong lane prior to the crash. And so, you know, how does it fit in? If you saw that and you believe that, and you're the part of the rapid response to the crash site, first person on the scene after the crash wasn't an ambulance, wasn't a police officer. First person on the scene was a representative of the company. So
Wow.
quite unusual.
So did they called a representative instead of 911, or was that your finding, or no?
Yeah, they contacted the dispatcher then at the company then contacted the police, but the manager, there was a manager at the, for the bus company,
Mm-hmm.
contacted their safety person, and the safety person was nearby in her car, and so she ditched her car and ran up the road, and she was the first person at the scene.
So was it ever determined who or what, like, caused the camera to go out? I mean, you said there was because you're with your testing, you determined in the test that it was, but did you guys actually determine what actually happened to the camera in the bus itself? Or was that determined by the court?
We didn't get access to the camera or the VCR that was actually in the bus. We didn't have access to that.
Mm-hmm.
There's a company employee that is visible on the tape. You see the person duck down on the video. We were able to show that to the jury. You see them duck down, crouch down. When you crouch down, that's where the VCR is, and that's where
Right before the crash?
it's it's after the crash. It's after the crash. It's our theory, and we proved that they deleted. They basically um, they basically deleted. It's not so much a deletion as they disconnected the camera and over recorded several minutes before the crash.
Were you able to prove that, or is that a hypothesis?
I think we proved it.
Yeah.
I think
Okay.
we proved it.
Prove
The
that
jury
through
said
what? The evidence of, is it like circumstantial, like because of the testing you did versus all the other evidence, or
yes.
how did you prove that?
Yes, I think a combination of and mind you that the level of proof for us is by preponderance of the evidence. We didn't have to prove to
Right.
the jury that absolutely, but more likely than not. And I think that given the amount of the damages awarded by the jury, they certainly didn't doubt that the bus company was responsible. They found that they were.
And so what was the outcome exactly numerically and everything else?
The total combined judgment was $36.5 million for
Wow.
the three families. I believe that my client's family was awarded, the client and her parents, I think it was $26.5 million.
Mm-hmm.
And then the other $10 million were divided between the other two plaintiff families. But
So you basically, that's a very, sounds like a very much a David and Goliath kind of case with what you were facing.
It was absolutely a David and Goliath. That was we spent 2 months on trial, and it was it was extraordinary to see these jurors. I mean, they were warned that this case would take at least a month. I didn't expect it to go 2 months, but it did.
Right.
Was and we also had a month of pretrial motions and hearings and whatnot. And I think we lost in the process. We lost one juror, had to drop off. I mean, we had a few extras, of course, but there was one juror who ultimately had some sort of, I think it was medical procedure or something that was excused. But seeing these people come back every single day, we were there, they were there. It's extraordinary. That's asking a lot.
It sure is. They also, like, I mean, we try to focus on the storytelling aspect of it, which you did a great job of leading us through, which we're going to wrap up here soon. But basically, one of the other things that in this kind of is part of storytelling, but this case doesn't sound like it was cheap for you or your team to pull off, with all the people that you're like flying to Washington, dealing with all these experts, paying them.
Yes.
So, but with this, so you were brought into the case. Obviously, your colleagues kind of believed in it too. Was it that scientific sort of because you have to tell yourselves a story internally. Like, you have to be like, why do I believe in this? Why am I doing this? Why am I spending a bunch of money on this?
Yes,
And how do you do that? Like, is
absolutely.
that, yeah,
Well, you, I, the further down the further, the further we went with this case, the more I believed. Um, I mean,
yeah,
maybe, you could say, Spencer probably still thinks I was drinking my own Kool-Aid, but it doesn't matter what they think, what the jury thought.
right,
And I had, I, I, I believed unequivocally that we unlocked the secrets of this case and what happened. And the case we presented made sense. It made sense. The idea that, that the testimony that was presented in support of the defense, it really didn't make sense why a person, why a young driver, yeah, shouldn't have been driving with anybody under the age of 18 in the vehicle with her, shouldn't have had passengers in the car with her, going a half a mile, has to drive a half a mile, and and suddenly, the testimony from the so-called eyewitnesses was that she just veered across the road into the path of the bus. There was nothing the bus could do. The bus is coming downhill around a curve to the left, and we were able to get in some evidence of the bus's speed. That was a huge issue because we had a big fight over whether it was thickly settled, or the bus company took the
it's a Massachusetts term. Yeah.
yeah, and it's like you can see the ball fields of the
Hmm.
of the school, and you're flying past them, and you think that the speed limit is 45 or 55 miles an hour, and you give your drivers the go ahead to go
Yeah,
fast on a two-lane road where kids are walking to school, and it's basically got no shoulder, and your bus is coming down a hill into a pretty good curve,
right,
to the right, and if you're speeding, as anybody knows, centripetal force pulls you to the outside of the curve. And so our theory was that the bus was going too fast, regularly went too fast, down that hill into that curve, and this young woman sees a bus, and the only person, from the sight line, the only person who could see the oncoming bus is the driver of the car. And there was the eyewitnesses were far enough back, so they had no view of what was coming. And there was a witness who came in who was in a car, in the passenger seat in a car that was directly behind, um, not the bus involved in the collision. There was a further back, following it was another school bus, and that driver claimed to have seen the whole thing.
yeah,
She didn't have the sightline for it. Actually, she said that she knew that this bus would be coming down the road. She stopped before the crash actually happened because she knew that that this bus would be coming. Behind her is a vehicle that stops, and they brought in not the person in the driver's seat, the person in the passenger seat who claimed to be able to see through a school bus, up and around a curve. Not credible. And then there was a car behind that, and they brought
right.
in a person from that car, also in the passenger seat. So
So you're
you're
really
witness.
drilling into the details. And that's really it shows how important that is. The other thing I hear a lot of what you're talking about is, and I find that this is effective in journalism too, is you're putting yourself as a character in the story in terms of I mean, at least I hear that in terms of this, trying to get this information and then discovering that their stuff is on this website. Like, you're kind of inserted into this narrative as a character. Like,
Sort of, yeah.
I mean,
Sort of.
because but I mean, at least in journalism, where we were encouraged to do that as an investigative reporter, because you don't want to. It's not to be egomaniacal or whatever, but it's because it's more transparent to your reader or your viewer. Because you're like, well, this is what I did. I discovered this. So you're saying, like, we tried to get this information from them, but then I just found it on their website, and then this is what we found. This is what they're doing. This is what how they've responded to these requests. Is that something you kind of, when you're talking to a jury, like, presenting that in that way in those parts of the story or the case, or
That is that that doesn't really come out in front of the jury.
okay,
That really and I think certainly not one of the things that well, one of the reasons because they they were not allowed to put forward a witness representative of the corporation. And they did bring someone from the corporation, the GPS company. They did fly him out to Massachusetts and
mm-hmm.
wanted the judge to put him on it basically in the middle of our case.
Yeah,
Um, and the judge said, no, we will, and we opposed that very vigorously because he was not the person that they produced for the deposition. The person they produced for the deposition was not an engineer. He was essentially like a customer service type of person, was not the same, it didn't have the same level of training and experience. And, and they had, there was additional material that they produced during trial and this was material from essentially from the GPS company
mm-hmm.
that was sort of sprung on us. And they made a decision who they were going to have testify as the company representative, and they chose somebody who really couldn't answer a lot of my questions.
Yeah,
And so you don't get to play fast and loose. There are certain rules that you have to follow, and if you do that, you run the risk of not being able to put on a different person. And in this case, the judge had did hear from the witness. There was a voir dire, which is a process of having a witness take the stand, take down their testimony. We got to ask questions. The judge asked questions. This is not in the presence of the jury.
yeah,
And then the judge makes a decision whether or not that person is going to be permitted to testify. And based upon the record being what, comparing what they were proposing to do at trial with what had happened before trial, the judge said, this is not fair. You can't have, somebody who is incapable of answering these questions when presented at a deposition and then do like a fast switch up and change it and have a different substitute for the chief of engineering. It's like that's just not how it's done. Um, if you wanted to have him testify, you should have produced him at the time.
yeah.
So,
So then, to kind of wrap up here, and this is a question I ask everybody, and it's kind of maybe a kind of a cheesy sounding question, but I always think it's a good question. And so
okay,
you've been, from what I understand, you've been practicing law for over 35 years, right?
that's right. That's
So
right.
in that time, and especially maybe even in this case, but just what's something you've learned during your career, or maybe from this case too, is that you that you didn't know before, that you learned from it, that you were surprised by, so in other words, if you could go back to and like talk to yourself in 1989 or when you started your law firm or whatever, and tell yourself something, not just like a, sort of a like a life lesson about everything, but just what's something you discovered that's surprising to you that maybe other people might not know or not realize
About myself or
about like practicing law and like presenting a case?
um, it's a great question. It's a really challenging question.
It's a hard question sometimes to come up with an easy answer, but
Yeah. And
sometimes there's things that you might be like, like if you had like, hey, here's
yeah,
1988 Lisa,
so
what would you say to her that's like a little surprising, like you're not going to believe
so
this?
what I would say to her, and um, what I would what I would say to many young lawyers is that we work really, really hard and to get through law school, to get past the bar. And a lot of us go through something, feel something that's referred to as imposter syndrome, where you just can't believe that you're really there, and that you're really able to do what you're doing.
Yeah.
And what I would say is ignore ignore that voice that tells you you don't belong there, that you can't really do this, because you can. And the biggest challenge you need to overcome is the voice, not what somebody else tells you about what you can do. It's what you let yourself think about yourself. Don't let yourself think that about yourself, because you do belong. You you do deserve to be there, and you can do it. And just wait. Just wait. You can let them think you're an imposter. It doesn't matter what anybody else thinks of you. I think a few people along the way who have greatly underestimated what I can do were very surprised.
That's great.
That was Lisa Parlagreco, appellate attorney in Massachusetts. Thanks again to her and you for joining us on Make Your Case. If you like this episode, hit subscribe so you don't miss what's next. And if you're an attorney looking to present your case more effectively, whether for mediation, settlement, or trial, head over to cleareyedmedia.com. You'll see how we help legal teams win cases and boost settlements with legal videos. And if you're a lawyer with a case or experience you think would make a great episode, email me at joe@cleareyedmedia.com. I'd love to hear about it.